He says they should not only get sued big time, but should also have to spend some years in jail for hiding the facts. Rich, I don't know about that. And talk to me a little bit about the duty here. It's a big issue in this case, the duty that they had. If Brian told them anything, they really didn't have a duty to go to police and tell, but it was the statement that was made that I think put them in a position where if they made the statement, then it was a lie.
That's exactly right. There was a motion to dismiss this case, arguing forcefully that there is no duty to come forward with information, but they didn't just stay silent. They issued a public statement or statements through their attorney expressing hope and indicating to anybody who read it that they didn't know if she was alive or dead. And the complaint alleges that, in fact, they did know she was dead, and the statement was made to induce false hope, to throw people off the trail, or for whatever reason. That is why they have potential liability in this case, because of the affirmative statement they made, not just because of a general duty.
In the terms of Bertolino in this case, and the lawyer and him being added to the case, his attorney's saying that the statement on its face can't be construed as intentional infliction of emotional distress, and it's an expression of hope. Do you think he might be removed from this case?
So I think that argument is a little bit of misdirection by the attorney's attorney. He is trying to parse the statements and saying, no, none of the individual words in these statements could have inflicted emotional distress. But the theory is that the parents and the attorney knew that she was dead. And by making those statements, they were giving hope where, in fact, there was no hope. So the theory is not based on the words themselves. They're based on the totality of the implication of the statement. And I think that is a plausible theory. The bigger question is whether or not they can get it to the attorney who is just acting as a spokesperson for the parents.
But Rich Schoenstein, I can make the opposite argument and say if this was some sort of, confession or referring to something awful her son did, why would I write burn after reading on the envelope?
Yeah, that's true, Michael. But you made the best point earlier. The biggest question with this letter is when was it written? I read the letter, and the first thing I thought of is The Runaway Bunny, a book I've read to my kids 100 times. This could just be a humorous riff on The Runaway Bunny if it was written 2 years before the murder. If it was written the week of the murder, it's an entirely different document. So I think finding out when this thing was written, when it was given to the son, is absolutely critical to understanding if it's even relevant to the case.
It is critical, but we do not know. It's not dated. This jury will ultimately, if it gets to a jury, is going to hear both sides. Arguments by, of course, the defense, suggesting that it was written long before. And of course, the Petitos are going to say it was written in response to what happened to Gabby. They'll have to make the ultimate decision. All right.